Hi students, today I will talk about Chapter 13, Consideration. Consideration is the inducement, price, or promise that causes a person to enter into a contract and forms the basis for the parties' exchange. Consideration can be anything that someone might want to bargain for. A promisor is a person who makes the promise. A promisee is the person to whom the promise is made. Oftentimes, consideration is referred to as bargained for exchange. Two elements of consideration. There are two basic elements of consideration. Value, which consideration requires a legal benefit to the promisor or a legal detriment to the promisee. Legal benefit means receiving something of measurable value. And you can see that in the text on page 326 when they talk about an act, forbearance, promise to act, or promise to forbear. The second basic element is bargained for exchange. Consideration involves reciprocity. The parties must bargain for whatever was exchanged when they struck a deal. Next, let's talk about mutuality of obligations. Illusory promise. An illusory promise is if one party's promise is conditional, the other party is not bound to the agreement. And we also talked in the last chapter about requirements and output contracts under the UCC. So see Chapter 11 for the definitions of those contracts. But Section 2-306 of the UCC expressly allows output and requirement contracts in the sale of goods. Pre-existing duty. A promise to do something the promisor is already obligated to do is not consideration. We learned in law school, past consideration is no consideration. Except additional work. When a promisor agrees to do something above and beyond what he's already obligated to do, the promise is generally valid consideration. The exception is modification. If both parties agree to a modification, the best solution is to rescind the contract and draft a new one. And there should be examples in the text when it comes to the exception of additional work when there is a pre-existing duty. Exception, additional work. When a party agrees to do something above and beyond what he is obligated to do, his promise is generally valid consideration. Except modification. Additional consideration is necessary for modification of a contract because it is unfair for one party to get something more while the other party does not. Another exception is unforeseen circumstances. When unforeseen circumstances cause a party to make a promise regarding an unfinished project, that promise is generally valid consideration. A covenant not to compete in an employment agreement is an agreement in which an employee promises to do work for a competitor for some time after leaving a company. It used to be that the covenants were rare and reserved for top officers, but now they've become pretty commonplace throughout many organizations. So in an employment contract, there are often these covenants not to compete, otherwise known as restrictive covenants, where an employee will sign that in his employment contract, agreeing not to work for a competitor within a certain time frame after they leave that employer or within a certain geographic location from that competitor. Promissory estoppel, we learned that a judge will often invoke the theory of promissory estoppel when, say, there is no contract, but in the interest of fairness and justice, a judge will allow recovery under the theory of promissory estoppel. So we talk about this with moral consideration, and you can look at that further in the text. Even in the absence of consideration, a court may enforce a promise if this will prevent a great injustice to the relying party. Some courts will require donors donating to charity to make good on their pledges to charities, even though the charitable organization has promised nothing in return, and that is called moral consideration. Okay, have a great day. Thanks.